something that is used to protect your brand, and specifically to prevent other people from using it. So when we think of a brand, what exactly does that mean? That could be a business name, a social media handle, like your social media name. It could be a logo. It could be a slogan. One of the easiest examples that I can think of would be Nike, right? So the name Nike itself, when people hear that, they automatically think of athletic products, or athletic wear. When you think of the Nike logo, most people can look at a pair of shoes, and if they see a swoosh symbol on the side, their mind goes to that's Nike. They don't think, oh, that's an Adidas or a Reebok shoe. And then the last thing, just do it. When we see that slogan on a shirt or in a commercial, we're automatically relating those to Nike. So your brand is what people think about, and how they relate that to the products or services that your business owns. And it's important because your brand can really help to sell your business, sell your products or services without you having to come forward to explain what it is that you do. Like I said, when we see the swoosh symbol or we see just do it, no one has to come and tell us that, oh, that belongs to Nike. Our mind is automatically connecting those things to Nike itself. And so, what we would not want is for us to build up a brand and build up a name and a following base around that brand itself and not to protect it. And then another company come in and use the exact name or a symbol or something extremely similar in the same industry. And people are now confused about who is the true owner of these products or of these services. And so trademarks are really meant to identify you as a brand and protect your brand so that no one else can get confused with who may offer similar services or similar products using a similar name, logo, or slogan. So that's a small overview. Now, when it comes to trademark protection, the most important way to get your trademark protected is through the United States Patent and Trademark Office. There are what are called state trademarks, which you can file with the state, similar to how you would file an LLC. And then you have your federal trademarks, which are filed with the United States Patent and Trademark Office. What exactly is the difference between the two? So a state trademark is only going to give you protection in your specific state. So if I file a state trademark in the state of Texas, it would only protect me in the great state of Texas. Someone else in California or someone else in DC could possibly use the same business name, logo, or slogan, whatever it is I have protected with that trademark application. And I wouldn't have really much to do about it because my trademark protection would only be in the state of Texas. And that is why we really advocate that our clients get trademark protection with the United States Patent and Trademark Office. This gives you protection in all 50 states. So whether they are in California or in Washington, D.C., or in Texas, you have rights to tell someone who is using your business name, logo, or slogan, whichever it is that you have protected, that they cannot use that for the same or similar services or products. And I know a few times I've said whichever it is you protected, whether it's your name, logo, or slogan. I'm saying this because when you do protect those items, they each need their own trademark application. So one application for your name, another application for your logo, and another application for your slogan. You can only protect one item on each application. And so that's why they have to be separated. When it comes to how long does this process take, if we file this application with the United States Patent and Trademark Office, it is a pretty lengthy process. But when you look at the overall benefit of having a trademark, it far outweighs the wait process. So right now, the typical wait time to have a trademark process is at about 10 to 12 months. However, I don't want you to think that you have to wait 10 to 12 months to begin using your brand name or your slogan or logo to advertise your services or products. No, you can absolutely start now. And it's important to know that when we submit that trademark application, we have to show proof of how you're using these items in order for the trademark office to say, okay, you know what? They actually do have a right to trademark this item, and they actually are using this to advertise or to sell products or services. So, yes, it does take 10 to 12 months, but you don't have to wait 10 to 12 months to start actually making sales. When you do the file an application as part of the federal trademark application process, some of the things that they're going to look for are number one, is your name similar to anything else that's already been registered with the trademark office or has a pending application? Um, if we think about Nike, for example, suppose that I wanted to start a company who was also going to sell athletic products and work with athletes, and I was going to name the company Fike. Fike. It's spelled different than Nike. It sounds different than Nike. And so it should just be different. And I'm going to try to file a trademark application for that name. The trademark application would actually get denied because a trademark doesn't just protect the exact name or logo or slogan, it also protects anything similar. So, because Spikey is spelled very similarly to Nike, it looks similar and it's pronounced similar to Nike, that would be too close to a registered trademark. I give you this example because I think that it's extremely important to know when you're looking to, one, figure out, do I have the right to trademark the name that I'm using? And is someone else's use of a name that's similar to my brand too confusing as to where I actually may have rights to enforce against them? And so likelihood of confusion is what this is called. When your name or your logo or slogan is too similar to something that's already registered or has a pending application. The second thing that they're going to look for is this a unique name? They want to make sure that you're not just trying to trademark a common name, right? So at the Curry Law Firm, we offer legal services. I could not submit a trademark application for the wording legal services if I'm going to offer legal services. It's not anything unique. It just describes the products or services that I'm going to offer. Now, when you have a name like um, Curry Law Firm, that is adding a unique identifier to it, because you're adding a specific name to that actual service listing. And so that will make it different enough, because I know some people may have their last name and then maybe tax firm or tax solutions, or something of that nature that would make it unique enough to go ahead and submit a trademark application for. So those are the two biggest things that I call them secrets, because when you're submitting a trademark application, those are things that you want to know before you even start that process. Number one, is there anything else out there that is very similar to what it is that I want to trademark, and within the same industry? And number two, is the wording that I would want to protect merely describing the services or products that I offer, right? Is it unique enough to actually protect with a trademark? And so I think those are extremely important to know. So the next thing that we're going to discuss is trademark enforcement. So if I have a trademark, what does that mean if I actually see someone else using that name or that logo or that slogan? And so what this means is that you have the right to send them what's called a cease and desist letter. Cease and desist means that you need to stop using it immediately, or I will take further legal action against you. And that's also a service that we offer here, right? So if you find out that another company has been using your firm's or your business's name and logo to get clients for the same or very similar services, and you're like, hey, there's people that are actually going to that company or going to that business thinking that they're purchasing products or services from me, that's confusing them, right? You can actually hire us to send a cease and desist letter to send to that company to let them know, hey, you can no longer use this name or this logo. Now, there are certain things, of course, certain factors that would need to be in play here in order to give you a strong enough claim to send a cease and desist letter. Number one, we want to make sure that that person hasn't actually submitted a trademark for the items that we're saying that they need to stop using. Number two, we need to make sure that you have rights to enforce here. So have you submitted a trademark application yet? Have you been using this name or this slogan longer than they have been using it? Do you have a brand following, as to where people were actually confused about who was the appropriate owner, and were people confused thinking that they were actually purchasing services or products from your company when they were actually purchasing them from another? And so when we're looking at enforcement, I think it's equally as important to know about enforcement as it is about the actual trademark process and steps to take, because once you have that trademark, you need to know what to look for so that you can actually enforce those rights that you waited 10 to 12 months to receive. And so cease and desist letters can absolutely help with that. Now, if people don't stop using the name once we send the cease and desist letter, you have the option to start litigation process. So that means actually filing a lawsuit against them, because you're losing out on money or on clients because they're using the brand that you have put in place. Sometimes we hear about these trademark stories in the news. One recently that I can think of was with Kim Kardashian. And so she was actually sued by a skincare line because Kim Kardashian began telling her fan base that she was going to come out with these skincare products using a name that was already trademarked by someone else for skincare products. And so that could possibly confuse people because she's now saying she's going to use this exact name that someone else is using within the same industry. Um, and another thing that I think is important to know is that if you're in a completely different industry, two people can use the same name. So when we think of the name Dove, Dove is used for cosmetic products such as like soaps and lotions and deodorant. And then we also know Dove, known for chocolate, right? They usually see them in like these little colored wrappers, and they're usually in a square shape. Well, those are actually owned by two different companies. They each have trademarked the name Dove, but they're in two separate industries. One sells cosmetic products and the other sells chocolates. When customers are going to shop for soap or for lotion, they typically don't find chocolate on the same aisle. And so, because the industries are unrelated, they can actually have trademark rights to the same name. And that's important to know because if someone is using your name in a separate industry, you may not have rights to enforce against them because they're in an industry that's unrelated to what you're doing. And customers may not actually be confused about if the two are actually related. Now, there are some people who probably say, I always thought that Dove Chocolate and Dove Cosmetics were owned by the same company, but they're not. So we've talked about the basics of trademarks. We've talked about what it is that you know. We've also talked about some of the basics. What is a trademark really meant to protect? And then we started to talk about enforcing trademark rights. And now we're going to talk about the trademark and what that means to work with a Curry law firm in getting a trademark. So when we have clients who are coming to us and they're saying, "Hey, I think I need a trademark for our business," we start by having just a short conversation with them so that we can make sure that we're actually obtaining the appropriate rights that they're looking for. Sometimes people may offer web courses, or they're selling some sort of document or booklet, and they're wanting to protect what they're selling in the e-course or what they're selling in the book, and that's actually protected with a copyright. And so the first step is to, one, make sure that you actually do need a trademark to protect, the item that you want to protect. So once again, the trademark is used to protect your name, logo, and slogan. There are others, but those are the main things that a trademark will protect. So when you come to us, we have that conversation with you and we make sure that those items can be protected by a trademark. Number two is that we're going to have you sign a contract with us and pay your invoice. And once that's been paid, we start doing research. So we'll never file a trademark application without first doing research to make sure that that name or that logo or slogan is available, because we've talked about the importance of making sure that you're not trying to file something that's too closely related to something else that's out there. And you don't want to try to file an application for wording that's just generic and isn't unique and can't actually be protected by a trademark. So those are the two things that we look for when we're doing our research. Then we come back to you and we say, hey, this is what our research discovered. We either did find current pending or registered applications that could prevent you from successfully trademarking your item, or based on our research, we think you have a really good shot at getting trademark approval. And so then we wait for you to say, ask any questions that you have, or for you to say, go ahead and file that trademark application. And so that is what the beginning process looks like. Once we have the go ahead from you to file that application, we submit your application on your behalf to the United States Patent and Trademark Office, and that's when that 10 to 12 wait period will begin. It'll actually begin once we submit the application. You'll get an update from us probably about every other month to say, hey, we're still waiting on your application to get assigned by someone to review it at the trademark office, or we'll let you know, hey, it's actually been assigned and here's an update. Once again, it takes about 10 to 12 months from the date we submit that application for it to get assigned and for it to get reviewed. Um, Once they review the application, they're either going to approve it for the next stage, or they're going to say, hey, we have some questions about your application. If they do have questions about your application, or they maybe need more information, such as additional proof of how you actually sell or advertise your product, such as a business card or a screenshot from your business's webpage, that typically is additional rates if we have to respond again. But we're more than happy to complete those services for you. And so once they have all the information they need, they're going to make a decision to approve your application or deny your application. 9 times out of 10, as long as there's no conflicting marks or conflicting names with what it is that you're trying to protect, and the wording that you're trying to protect is unique, they're going to approve your application and move it on to the next stage. Um, and then the next stage is pretty much like a posting to let the general public know that, hey, you're going to seek trademark protection of this wording, and make sure that no one else feels that it could possibly conflict on their rights to use their trademark. Now I know you're thinking, hey, we just waited 10 to 12 months, and now you're telling me that someone could say, hey, I think that their use of a trademark is too similar to what I'm trying to trademark. Well, the standard for this is pretty high. Someone would have to prove that their business would lose out on clientele or on monetary benefit, and they would actually have to argue before the trademark office and pay a pretty hefty fee in order to submit this opposition. So most of the time, trademark applications don't get opposed, but it's always a possibility that we like to make sure that you're made aware of. Once you pass that 30-day period and no one has opposed your application, good news, you become a registered trademark. In total, the process takes about a year and a half on the long end if we have to respond to any questions that they have. But like I said, it's absolutely worth it because now you have intellectual property rights, which are what trademarks are. And you have the right to tell other businesses or companies that, hey, they can't use your brand items because you have actually trademarked these items. So I like to open it up now for questions that you all may have about trademarks, the trademark process, enforcing those rights, just to make sure that you have a good understanding of trademarks and you also have an understanding of how we can be a benefit to you within this trademark process. Is a trademark limited to the US or is it international? Great question. So, a trademark that's filed with the United States Patent and Trademark Office is specifically for United States protection. However, because the US commerce system is works globally, right? You may have a company in China who specifically markets to US clientele or US customers. You can actually have your United States trademark, once it's registered, recognized by other countries. And so the first step is to get your trademark registered with the United States. And then there are other countries that the United States has agreements with that will actually recognize your US registered trademark. So I know for sure the UK is one, but it would just depend on the specific country that you're looking for that international protection with, because you do have to request that your United States trademark is recognized by each country that you may want to work with. So I had a client who worked heavily in one of the Caribbean smaller countries, and they did recognize it. And so once we had the US trademark, then we just went ahead and alerted them that, like, hey, we have a registered trademark here that we would like you to recognize, and you do pay an additional fee. But the process is a lot shorter than the 10 to 12 months, and they'll agree to recognize it. Now, some countries do recognize it. I'll say most countries do recognize the US trademark just because the US is so big, but there are a few countries that don't recognize it. So I would need to search for something similar sounding names in my industry internationally in order to get the international protection. Yes. And so, like I said, when we're filing within the US, we do check for the exact same name and similar sounding names when we're doing that research before the trademark application is filed. But if you know that you have a significant client base or customer base in a different country, that would be research that would need to be done just to make sure that you can adequately enforce your trademark protection there. Any other questions? And we are recording this so that you can come back and review the information at a later date. I know there's so much information that we discussed, and when you're learning new information and it's all coming at you at once, sometimes it can be a little overwhelming. And so later, if you have to go back and scroll to 5 minutes and 33 seconds and see what exactly did we discuss here, and you want to set up a time to talk with us about the trademark process, you can always do that as well. Okay, well, I know this is the lunch hour for a lot of people. So if there aren't, oh, someone else is typing. But if there, once we finish these last few questions, I'll go ahead and wrap it up. Great question. The question is, will you ever have to renew a trademark or is it everlasting? So a trademark actually has to be renewed every 5 years, but it's not as expensive as when you pay for it the first time. So the trademark renewal fee can change. Right now, it's set to the cost of the application filing, which is $250. So for clients who are coming to us asking us to renew their trademarks because it's been 5 years, 10 years, or 15, the application fee, just the application fee, is $250. Now, of course, you would need to pay for the services for us to file those documents for you. And so you do add on legal service fees to that. But the cost to renew right now, the application fee for that is $250. You'll need to renew your trademark every 5 years. And if you don't renew it, you lose it. Our websites and email addresses included under a trademark. I've searched for email handles, and the best one, typically a .com, is taken, but I can't find an actual company online. Great question. If someone has your domain name that you want, they would need to be using it for the same or similar services for you to enforce trademark rights against them. I gave the example of Dove. Well, Dove chocolate could have Dove.com, and Dove that sells cosmetic products couldn't force them to relinquish that domain name simply because it's the same name that they have trademarked. That business actually has to be selling the same or similar products or services that you offer for it to be considered trademark infringement. But there is laws that protect domains so that if you have a registered trademark for a name or for a similar name that someone has a domain for and they're selling the same or similar products, you do have rights to enforce against them. Yes, absolutely. Well, I think that will wrap up the questions that we have. So thank you so much for taking the time to listen to what we have to share about trademarks. Like I said, if you have any questions or would like to contact our firm to learn more about the trademark services we offer or book some time to speak, you can contact us at 713-574-2070, and we would love to speak with you. You guys have a great day.